All right, hi again. Welcome back, Attorney Steve Vondran. Welcome to another exciting episode of Contracts College with Attorney Steve. All right, guys, we are talking about something fun today, Promissory Estoppel. Doesn't that just have a beautiful name to it? Promissory Estoppel, one of those legalese words. Well, here we have it today. Von Deasy, law made easy in Contracts College. All right. Okay, so normally, here's the situation. Normally, to have an enforceable contract, you have to have the two parties bargaining for something. What we call here, let's go to the litigation whiteboard, what we have the offeror. That's the one that makes the promise. Also known as the promisor. They make the promise. Promisor, offeror. And over here you have the other party, the offeree or the promisee. Okay, this is Contracts 101, and we're going to talk about that. So here you have the offeror or the promisor making a promise, and the other party is normally saying, yes, I will do something as well. Bargain for legal exchange, bargain for detriment, creates the contract. That bargaining is the consideration that binds the contract, as I was taught in law school. But how does that work when there is no consideration? If there's consideration, go file a breach of contract. I agreed to paint his house for $10,000. He said, yes, I'll pay you $10,000. I went and did something I didn't have to do. I painted the house. I came back for him to give me the money, and he didn't give me the money. We had a promise. Maybe there was a written contract even, and we had a promise, and he didn't pay me. That's just a standard varietal breach of contract. But in promissory estoppel, you're typically not going to have that written contract, and you may have a party trying to back out or change their mind or say, well, I was just joking, you know? So you don't try to hold that against me. You didn't give anything of consideration. There is no contract. Ha ha. There's no contract because you didn't give any consideration over here, Mr. Offeree. Okay, that's how these cases arise. This is I'm talking about California right now. California law. Check your states. Things could differ. This is not legal advice, general legal information only. But in California, you bring it as a cause of action. And this is what we call promises enforced or enforceable without consideration. So this party will typically give no consideration, and so you won't have the glue that binds the contract. But you have this person who has suffered an extreme injustice, something that many people would say it's unconscionable that this person would not be able to find a way to recover against this person, the promisor, the offeror, okay? So usually you're going to have unjust, or what we call unconscionable detriment. You can find this under Section 90 of the Restatement of Contracts, and we're really generally looking at a common law defense, something created by the courts, to do equity. What is equity? Do what's right, do what's fair, what's just. Okay, so in these cases, you're not going to get a jury trial. I have here that it's enforceable in equity. It's the judge that's going to decide what's a fair way to resolve this. And usually the standard is you enforce this promise to the extent necessary to avoid an injustice, to the extent necessary to avoid injustice, and then no more. Just what you have to do to make things right, okay? Estoppel, you may be saying, well, what does estoppel mean? I see that everywhere. Estoppel just means the person who makes this promise is going to be estopped from saying that there was no contract, there was no writing. Maybe there's statute of frauds here. Maybe that was an offer about building on my real estate. I said, if you go to law school, I will sell you my house. And the guy goes to law school, the offeree goes to law school and says, okay, I'm done, sell me your house. And he says, no. I'm not going to sell the house. I was drinking over here. I was drinking. This was just a preliminary discussion. I was intoxicated. It was a vague promise. That's not really what we talked about. So it's a gratuitous promise. It's not enforceable. Ha ha. But you did get a legal education. Good for you. Well, this person may have said, look, I had no intentions of going to law school or anything. I paid rent. I paid tuition. I did things I can't even tell you. 3 years of turmoil in that thing they call law school. And I want that money back. I want to be compensated. I hate law. I never would have even done this. Just an example, okay? So here we have it. So what we look at in a promissory estoppel, we want to look at the offer. Is there definite in certain terms? D and C. This is with any contract. Is there definite in certain terms? Is there a clear promise? You go to law school, I will pay your tuition. If you do that and the person says, wow, that's free. That's like basically free education. Oh my God. You know, you can argue whether that's really a legally recognizable form of consideration. That can be argued. But let's say the court assumes that that was a gratuitous promise, unenforceable by contract law, but enforceable under equitable principles, promissory estoppel. So we look at these things, no preliminary negotiations, no vague terms. Well, I was saying that around a campfire. I was, 2 bottles of Jack Daniels in. I don't even know what I was saying. That's a defense to contract. Anyway, you never know what's going to come up in these cases. Next, you're going to have to show this party, which will be the plaintiff in the lawsuit, is going to have to show justifiable reliance. Objective in the world of contract law, it takes the objective theory of contracts, meaning what would a reasonable person do? We don't say, well, you're kind of, not very smart and you made a really stupid decision. We look at reasonable reliance. If I say you go to law school and I pay for it and you go buy a penthouse, you rent a penthouse for $60,000 a year, that's probably not a reasonable response to an offer like this. So the courts will look at the objective theory of contracts to see if you were induced to take an action or a forbearance, what we call detrimental reliance, okay? So you have an offer that's clear and certain, you have reasonable to take justifiable reliance by the offeree, the promisee, and then you have justifiable change in their position and damages. You have some clear damages that are reasonable in scope. Some would say an unconscionable injury has occurred that only equity can prevent. Again, no jury trial. Okay. So that's it. That's really kind of what you're looking for. You changed your position in reliance on a promise. If you have something that should be under the statute of fraud, like real estate contracts, this can even work as an exception to the statute of frauds. Most people don't know that. You catch that on your bar exam, guys. Boom. Gonna kill it. All right, so you have gratuitous promises, you have action in or forbearance, detrimental reliance, unconscionable detriment, and you make your plea to the court and your cause of action. Judge, even if this is not a contract, I gave no consideration, there was no bargain for legal detriment, judge, this is promissory estoppel. I am out this money, it's reasonable. Anybody would have suffered the same amount of damages had they been made the same promise to them. He has stopped from saying there's no contract, that there was no promise, or this, that, and the other. He's a stop. Promissory estoppel, you guys, a great legal doctrine. Now, closely related is, let's say the judge says, I don't think this was a gratuitous promise at all. I think there was a bargain for consideration. You went and did or refrained from doing something that you didn't have to do. I think that's consideration. The closely related cause of action would then be for breach of a oral contract, okay? California, you're looking at a 2-year statute of limitations as of the date of this video. But again, general legal information only. Do not rely on this video. Could change, could be wrong. You never know. Not usually, but could be wrong. So anyways, guys, that's promissory estoppel. Now you're smarter than the average bear. So you bring that up at a cocktail party. Hey, that sounds like promissory estoppel. Man, you're killing it now. You're killing it. Guys, thanks for watching. This is a quick overview, general legal information only of promissory estoppel. Have a great day. Bye now.